Hi, everybody. We're just going to wait a little bit for more people to come on. We're just starting our program, and we're just going to wait for 1 to 2 minutes for more people to join. There is also a comment section for anyone who wants to ask any question or make any comments. Feel free there, and I can also respond to you live as well. But like I said, we're just going to wait 1 to 2 minutes and make sure I see more and more people are logging in. So we're just going to give everyone a chance to get on. I hope everyone is having a lovely evening. I know someone in Hawaii logged in, so I don't think it's afternoon there. Hi, Cappy. Okay. I think with that, we are going to start. Hopefully everyone can hear me and see me okay. My name is Yifat Shaltiel. I am a reproductive law attorney. I practice in New Jersey, New York, and Pennsylvania. I'm also director of Surrogate Steps, a surrogate matching agency. You can feel free to ask me any questions that you might have, either in the comments today, or if you want to contact me after today, you can reach me via email at ys@surrogatesteps.com. That's ys@surrogatesteps.com. Or you can feel free to also give me a call at 607-229-6503. Again, that number is 607-229-6503. Let's see how we're doing. Okay, so I first want to say thank you to CNY for hosting this Facebook Live event, and I want to thank Jake from CNY. He's on here with me today and assisting me with the slides that we have for you. And with that, Jake, let's go to our first slide. Thank you. So today, we're basically going to cover New York law and surrogacy laws in New York. This is going to be useful for anyone who is looking to build their family through surrogacy in New York using a New York surrogate. And this is going to be helpful whether you are self-matching or if you are matching with an agency. So I hope that I can give you good information today. And once again, like I said, feel free to post your questions in the comment section if you would like. Okay, let's go to our second slide. Hi, Holly. Okay, so let's start with what is a surrogate. Hopefully, I believe most of you already know, but I just want to cover it for the people who are completely new to this. A surrogate is a woman who agrees to become pregnant through assisted reproductive technology, and she's going to carry a child for the intended parents. There are two types of surrogacy arrangement. There is the traditional surrogacy, also known as genetic surrogacy, and then there is gestational surrogacy. Let's go to the next slide. Traditional and genetic surrogacy is an arrangement where a woman agrees to become pregnant using her own egg. So in traditional surrogacy, the surrogate is going to be genetically related to the baby that she is carrying. Next slide, please. And this is different than gestational surrogacy, which is an arrangement where the surrogate agrees to become pregnant for the intended parents or intended parents through assisted reproductive technology, and she carries a child for the parent that is not genetically related to her. So the child is either going to be genetically related to the parents, or perhaps an egg donor might be used, but it's not going to be the person who's actually carrying the child. Next slide. And this is an exciting one. So the ban on compensated surrogacy has now been lifted in New York State. New York does legalize compensated gestational surrogacy, where there is no genetic connection between the surrogate and the child that she's carrying. And that is as of February 15th of this year, that compensated surrogacy was codified into law in New York. Just a little bit of background. There were various forms of compensated surrogacy that were introduced, including the Child Parent Security Act, which is what was passed, and the bill finally passed as part of the governor's budget. It was finally the law caught up with the science, and it took us a long time. New York was one of the last 3 states to legalize surrogacy. With that, let's go to our next slide. Okay, so the great thing about our new law is that it does acknowledge parentage through intent. So a non-biological intended parent can now be recognized as legal parents even when they're using a donor, or before they might have had to do an adoption. So there's no longer any discrimination based on sexual identity or any type of preferences. The intended parents are going to be the legal parents by law, so long as the surrogacy agreement meets the material requirements of the law. Okay, next slide, please. And just so we understand, once again, it is not applicable to genetic surrogacy. Not a lot of people do genetic surrogacy. I certainly have had a few clients who did, but if you are doing genetic surrogacy, we're going to have to use the old law, and we cannot have a gestational carrier agreement in place, and there might be an adoption involved. So genetic surrogacy is not covered under the new law, and any contract relating to a genetic surrogacy is going to be void and unenforceable. Next slide, please. Okay, so part of what we need to look at when we're looking at the surrogacy arrangement is the marital status of the parents. So the question is, who can really enter into these type of agreements to benefit under the new law? So to enter into an enforceable surrogacy agreement, at time of execution of the agreement, the intended parents must can either be a single adult that is not in a spousal relationship, or it can be 2 spousal adults together in a legal relationship, whether it's married, a civil union, or a domestic partnership, or any 2 adults who are intimate partners together. So they're intimate but not married. And it can be 1 adult that is also in a spousal relationship. However, they have to be living separate and apart pursuant to a decree or judgment of separation or a recorded written separation agreement, or they have been living separate and apart for at least 3 years prior to the execution of the gestational carrier agreement, or the non-participating spouse. So the non-participating spouse will not be acknowledged as the intended parent so long as we follow this arrangement. But if the non-participating spouse if it's their genetics that is being used, then you have to be careful. And then there's a lot more things to consider, like the consent agreements that everyone signed and the custody of the embryos. And that can get very, very messy. So definitely involve an attorney if that is the situation. Okay, let's go on to our next slide. The divorce of intended parents. Surrogacy agreements must provide that the intended parents agree to be responsible for the support of all resulting children upon birth. So if the intended parents execute and they enter into an enforceable surrogacy agreement, then a separation or a divorce of the intended parents will not affect the intended parents' rights or their duties or their responsibilities that they have to the surrogate and to the child that they conceive. So, for example, the parents are still going to be held jointly and severally responsible for all the obligations that they have, both for the child as soon as the child is born, as well as the surrogate. Next slide, please. Citizenship and residency. To enter into an enforceable surrogacy agreement, at time of the execution, when everyone signs the agreement, citizenship, there are certain citizenship and residency requirements that must be met. The surrogate must be a U.S. citizen or a lawful permanent resident, and she must be a resident of New York for at least 6 consecutive months. And at least one of the intended parents must be a U.S. citizen or a lawful permanent resident. And that intended parent must have also been a resident of New York for at least 6 months. Okay, let's jump on to the next slide, but let me just take a look because you guys are posting a lot of comments here. Okay. So I don't really see any questions, just I see that you all are just posting general things. Okay, so we'll continue. Compensation. So the surrogate may be compensated. Compensation is for the medical risks that the surrogate is taking, the physical discomfort that she's undergoing, and the inconvenience and responsibilities that she's undertaking in connection with that surrogacy arrangement. Compensation cannot be conditioned on any outcome. So it cannot be conditioned on how many embryos are created. It cannot be conditioned on whether or not there's a live birth or if the child is healthy. The compensation also has to be placed in an escrow, and it has to be done before she starts her medication. And that's her full compensation that must be in escrow before she starts medication. The final payment that is made to her must be no later than 8 weeks post-delivery. And there is no minimum compensation requirement. It is negotiated between the parties, and it needs to be obviously based on good faith and hopefully standard, what is standard in the industry. All right, let's go on to the next slide for the eligibility of the surrogate. Thank you. To enter into an enforceable surrogacy agreement, the surrogate, at time of execution of that agreement, has certain requirements that the new law requires her to have. So, as we already stated, she has to have certain citizenship and residency requirements. She also has to be at least 21 years old. She must be a gestational carrier, because once again, this does not apply whatsoever to traditional or genetic surrogates. And she must pass medical evaluation by a healthcare practitioner relating to the anticipated pregnancy, including the screening of her medical history and evaluation of known health conditions that may pose risk to the potential pregnancy or the embryo during the pregnancy. Okay. Thank you. She also has to be provided informed consent to be a surrogate after she has been informed of the medical risks of the surrogacy, which includes the possibility of multiple births, the risk of due to medication and complications of the pregnancy, any psychological and psychosocial risks that might impact her personal life as well. She must be represented by an attorney, by an independent attorney other than whoever is representing the parents, and it has to be paid for by the intended parents. And it also needs to be a New York, an attorney who is in fact licensed in New York. There's also a health insurance requirement that she has to have life insurance and that she has to have health insurance, which we're going to talk now in more detail. Next slide, please. Okay, so in terms of the health insurance for the surrogate must have a health insurance plan and policy in place, and it has to be in place and effective before she starts her medication, before any type of treatment for an embryo transfer. The health insurance has to cover the preconception care, the prenatal care, and any major medical treatments such as hospitalization and behavioral health care. The policy has to be for a term that extends throughout the surrogacy pregnancy, and it has to go up to 12 months post-pregnancy. So it starts from the time that before she starts any type of medical procedures and medication for her embryo transfer, and it has to continue 12 months post-birth. The intended parents have to pay the premiums, the deductible, the copays, and all the out-of-pocket expenses. If you have a compassionate surrogate, she can waive the payments by the intended parents, but she cannot waive the health insurance requirement itself. So the health insurance still has to be there. Okay, next, please, for life insurance. So in terms of life insurance, the surrogate also, the new law requires her to have health and life insurance in place before the start of medication or prior to any treatment for an embryo transfer. Life insurance must provide coverage of a minimum of $750,000, and that's going to be for the benefit of any beneficiary that the surrogate designates. Or if she's not eligible for $750,000, then it's going to have to be whatever the maximum it is that she is in fact eligible for. Once again, it has to be for a term that's going to be throughout the pregnancy and then 12 months after the pregnancy. So after live birth, when it talks about until post-pregnancy, it doesn't matter if there's live birth or not actually. So even if there's a miscarriage or anything like that, it still has to be 12 months after that. And once again, it has to be paid for by the intended parents. And if you, again, have a compassionate surrogate, she once again can waive the payment by the intended parents, but she cannot waive the requirement that she must have that life insurance in place. And once again, up to $750,000 or whatever the maximum amount that she can obtain and that she's eligible for. So sometimes surrogates do have life insurance policies with their employer, but it has to be $750,000 or whatever the max that she is eligible for. And that sometimes is going to be different than what her employer, the benefits that she would receive through her employer. So if you're working with an attorney or an agency, they're going to help you figure all of that out. Okay, let's go on to our next slide. Thank you. The surrogate does have a right to request that the intended parents also provide her with disability insurance policy. If you are trying to be a surrogate, and that is something that's actually quite difficult to obtain. However, she has a right to request it, and if she requests it, then the intended parents must provide her with such a policy. And it is going to be her decision completely as to who she would like to designate as her beneficiary for that policy. Okay, next slide, please. This is really important. Intended parents have to have a will in place. This is something that we are very careful with in our agency. The intended parents must execute a will prior to the embryo transfer. The will must designate a legal guardian for any resulting children, and the will must authorize that the executor is able to perform the intended parent's obligations pursuant to the surrogacy agreement. So the new law in New York requires it, but this should really be standard in the industry. It is very, very important. Okay, next slide, please. Okay, so surrogacy matching obligations. There are certain things that must be in place in order for your gestational care agreement to be valid, in order for you to actually use the law properly and be able to be recognized as legal parents through using this law. So, must ensure that the surrogacy agreement meets all the requirements of the New York law. If you're working with an agency, the agency is going to have the obligation to do that. If you're self-matching, then your attorney is going to make sure that that is in place. There also has to be informed consent, and that has to be given to everybody, all the parties, the surrogate spouse, if that's applicable, as well as the intended parents, and they all have to receive it before they enter into an enforceable surrogacy agreement. The surrogate also has to be provided with what is called a surrogate's bill of rights at time of the initial consultation, and there has to be monitoring of the parties to make sure that everyone is complying with the terms of the gestational carrier agreement. And if you are working with a surrogacy agency, there must be training materials by that surrogate agency that they're going to provide to the staff to make sure that all these requirements are being met. So if you're working with an agency, all these obligations are going to be up to the agency. If you are self-matching, the law is not fully clear, but my colleagues and I all agree that it's going to be the attorney who is going to have to make sure that everything here applies. Okay, next, please. The informed consent. So the surrogacy program or the attorneys will obtain written informed consent from everyone before they enter into that agreement. And this is a separate informed consent than what the clinic is going to obtain from the surrogate and the parties. So the fertility clinic will still be obtaining their own informed consent, which some of you might already be familiar with. And it's going to basically say that the surrogate is consenting to the IVF, to the embryo transfer, and to all the medical procedures and treatments that she's going to be receiving. And that is going to be a different informed consent than what she's going to also need to receive from either the agency or the attorneys. The clinic must obtain that informed consent from the surrogate before she starts her medical, any medical evaluations for her embryo transfer. Okay, next slide, please. So here we have the requirements, so you all are aware of what the informed consent is going to include. So the surrogate, the informed consent is going to include that the surrogate was informed that her name, her address is going to be kept on file by the surrogacy program if you are using an agency. That the surrogate was also given the option to enter into a voluntary sharing information with the surrogacy registry. And I'll talk about that in a few minutes, that there's going to be a surrogacy, or there is a surrogacy registry now in New York, and she's going to know about that. She's going to be able to enter into that upon completion of the surrogacy agreement. That the surrogate, in fact, consents to the HIPAA authorization to be provided to the intended parents and their physicians in regards to any relevant medical history. That the surrogate has a right to terminate the surrogacy agreement, the gestational carrier agreement, anytime before she becomes pregnant by means of assisted reproduction. And she also needs to be provided with the surrogate program screening criteria, and again, a copy of that surrogate bill of rights. And all that needs to be included in that informed consent. So with that, let's go to the next slide so you can see what the surrogate bill of rights looks like. So the surrogate is going to receive her surrogate's bill of rights at the time of the initial consultation. If you're working with an agency, your agency is going to make sure that they're following the law, hopefully, and that the surrogate is going to get her surrogate bill of rights. If you're self-matching, then it's going to be up to the attorneys to provide that. The surrogate bill of rights includes the following. So she has a right to make her own health and welfare decisions, meaning she has authority to decide if she wants a C-section, if there's going to be a multiple embryo transfer, choosing her own healthcare providers, and terminating or continuing with the pregnancy. And I just want to touch base on that just briefly, because I don't want anyone to get scared. When it comes to things like that, obviously it's the surrogate's right. She's going to have a right to choose that. But when you're working with an agency, or if you are self-matching, one of the most important things is that we make sure that there is proper screening in the beginning, that we know what the surrogate is going to want, and that the surrogate's requirements and what she would like to do and her health decision making is going to be similar to that of the intended parent, so that everyone is on the same page. So even though, of course, Surrogate's Bill of Rights is going to say this, and this is the New York law, of course, and no one's going to make her do something with her body, obviously, that she does not want to do, But that is why it is so important to have that screening in the beginning to make sure that everyone is in fact on that same page. Okay. She also obviously has a right to her own independent counsel, which I think we covered briefly. She's going to have the right to health insurance and medical cost coverage. And again, this is all included in the form that she receives, which is the Surrogate's Bill of Rights. So she's going to see all of her rights right there. She has the right to obtain counseling. She has the right to have life insurance coverage and the right to terminate a surrogacy agreement before she becomes pregnant. Okay, let's go on to the next slide, the surrogacy registry. Okay, upon completion of each journey, or excuse me, upon completion of each agreement, regardless if the surrogate might have been a surrogate before, or if she had been asked this question before, or if she refused, the surrogate will be asked if she would like to participate in what is called the surrogacy registry. The surrogate will receive written informational materials regarding the surrogacy registry, and the participation of her entering into that is completely voluntarily. So she has to be asked if she wants to participate. She has to be provided written materials, but she has the right to say yes or no. It's completely up to her. Next slide, please. And the written materials are going to basically say exactly this, that participation is voluntary and her consent can be revoked, that the information, her information is going to be de-identified and decodified. So the surrogate is going to remain anonymous. So it's not like her name is actually going to be on the registry. And the surrogate program is going to follow all the laws that they need to follow in order to make sure that everything stays confidential. Okay, let's go on to the next slide. So same thing if you're using an egg donor. So I know some of you are going to be using egg donation, and just letting you know, so it's going to be very similar with the egg donors. There's an egg donor registry, ova donation registry, and it's the same thing. It's going to record the number of ova retrieved and the number of times that donor has donated. It's going to include the health information of the donor at the time of donation, and obviously anything else that the Department of Health deems appropriate. But again, it's voluntary. The information is going to be de-identified. So she's going to stay anonymous. Okay, next slide. So similar to the surrogacy registry, just want to make sure everybody knows, because I know some of you are using egg donors. Post an egg retrieval procedure, that's when the egg donor is going to be asked if she would like to volunteer and participate in the ova donation registry. And then post that procedure, the clinic is going to give her the same type of written materials that they do with the surrogates. And it's going to say exactly the same thing, that she can participate in it. The participation is completely voluntary. She can withdraw it at any time. The information is going to be de-identified. She's going to remain anonymous, and that the clinic is going to make sure the information stays confidential, and that obviously they're going to comply with the law. Okay, next slide, please. So the new law legalizing surrogacy is great, but it did pass the legislation in the midst of COVID on the last day of legislation. And there are several areas that the new law really created some issues. And so we're working on passing, well, by saying we, a lot of attorneys are working, and Assembly member Amy Pollan is working on getting a cleanup bill passed. And the cleanup bill is in legislation right now, so we're going to see what happens with it. But it does things just to make things a little bit more clear. For example, right now it says surrogacy agreements must identify the surrogacy matching program. That language in the new law makes it a little bit unclear whether the New York actually is requiring that a surrogacy program and an agency be involved in the matching. And so the new bill is going to make that a little bit more clear to say that no, we can have independent matches too. Same thing with the life insurance and health insurance. It specifically specifies for a term, and that can get complicated. So we're going to try to remove that wording as well. And for the disability insurance, as you recall, I said a little bit earlier that if you are looking to be a surrogate, it can be a little bit difficult to actually obtain disability insurance once you've already started getting tested and done medical screening. So one of the things that this new law will do is, instead of just saying disability insurance, it's going to propose other type of options, such as another insurance coverage to cover lost wages or reimbursement for lost wages by the intended parents. Okay, how are we all doing? Is everybody okay? I'm just looking to see. Okay, so I think some of you are asking questions. Kathy, your questions are really long, but let me get back to them towards the end, okay? So parentage. So the nice thing about this new law is that the parents are going to be the legal parents by operation of law. Court intervention is still going to be necessary to obtain that order. But as long as the parents and the surrogate all follow the law and all the material requirements of the law are in fact met, they're going to be, by operation of law, designated as the legal parents. Okay, next slide, please. Oops, next slide. Thank you. So what happens if we fail to comply with the new law? If there's no gestational carrier agreement in place, how really will the intended parents going to become the legal parents? So not everyone is necessarily going to fall into this new law. Maybe someone doesn't meet the citizenship or the residential requirements, or perhaps someone is using traditional surrogacy, so they're not going to fall under this new law. So the way that we're going to determine parentage for them is under it's under the old law. So we're still going to be able to obtain parentage. It's just not going to be by operation of law in accordance to our new law that we have. Okay, next slide, please. Okay, the benefits of the new law. So the ban on paid surrogacy has been lifted, which is wonderful. We have legal protection for the parents of the children that are conceived through artificial insemination. We now have surrogacy agreements that are enforceable, and that really protects all the parties. And New York is very, very good at enforcing contracts. They like to do that all the time. It's aided for potential adoption process and having multiple hearings in court. So there are a lot of great benefits to this law that we are looking forward to obtaining. Okay, so with that, we are almost done. Let me just take a look at some of the comments here and read them to you. Let's see. Okay, so I'm clicking on the comment, but I don't know that you guys can see it. So the comment is, what if, oh, thank you. What if both intended parents are foreign, not from New York or from another country, and the baby is born in New York? Does this mean that the act does not apply and therefore an adoption must occur? So as of right now, we're going to need to use the old law, and they're going to potentially need to do an adoption because they are not New York residents. At least one of the intended parents must be a New York resident, and and that particular intended parent also has to be a resident of New York for 6 months, not to mention that they also have to have citizenship or be a lawful permanent resident. So yeah, they are going to, in fact, need to do that. Let me see what else. Okay, here's another comment. If the surrogate must have already passed a medical exam to determine her eligibility to carry at the time of execution of the gestational carrier agreement, is the surrogate responsible for covering the cost of the medical exam herself? Because at that time, the intended parents are not contractually obligated to cover the cost. That is an excellent question. The answer is yes, the intended parents are in fact obligated to pay for those costs. And even though they might not have an actual gestational care agreement in place, under the new law, it does require them to do that. And that's a requirement that they must show that they adhere to in order for them to comply with all the material requirements of the new law. Okay, does anybody else have any questions? Let me see what else we have here. Okay, Elizabeth says, my sister's on her second journey, but in Maine. I guess surrogate-friendly states are few and far between. So actually, no, we have a lot of good states that are surrogate-friendly, and finally, New York is now one of them. But there are a lot of great states, and I would say feel free to contact me, and I'm happy to talk about that further. Let's see. Hi, Kimberly. Okay, I think that's everyone. Does anyone else have any other questions? Let's go on to our last slide. Thanks, Jake. Can we still see the last slide? Thank you so much. Okay, so I just want to put my contact information there for you guys. Again, my name is Yifat Shaltiel, and you can reach me at ys@surrogatesteps.com. That's ys@surrogatesteps.com. You can reach me by phone at 607-229-6503. And I'm really excited to have been here with you. I myself went through my own infertility journey, and I can understand the process. It's very emotionally taxing, I know. And for everyone that tuned in today who is also contemplating being a surrogate, thank you for the amazing work that you're doing. It's really quite an amazing miracle to give someone. There's really no greater gift than the gift of life. And thank you for everyone who's doing that. And thank you again to CNY. So with that, I'll say goodbye for today, and hopefully I'll see you all soon.